Oyez, oyez, oyez. The Honorable Supreme Court of Arkansas is now in session. All persons having business before this honorable court, draw near, give attention, and ye shall be heard. May God save these United States, the state of Arkansas, and this honorable court.
Good morning. Welcome to today's session of court. We have a couple of cases to hand down today. We have CR 21-148, Stanley Warner versus State of Arkansas from the Van Buren County Circuit Court, affirmed.
CR 20513, David Edward McLaughlin versus State of Arkansas from Garland County Circuit Court, affirmed. Justices Womack and Webb concur.
Will the clerk please read the submissions?
There are 3 appeals being submitted to the court for decision today, the first of which will be our oral argument, Civil Case 20-568, Jane Doe and Mark Myers versus Amy Fecher in her official capacity as the Secretary of Transformation and Shared Services, and the Arkansas Democrat-Gazette, an appeal from Pulaski Circuit. Also, we have criminal case 21-29, Karen Siegel versus the State of Arkansas from Craighead Circuit, and civil case 20-643, Medicana LLC and others versus the Department of Finance Administration and others, an appeal from Pulaski Circuit. In addition to these 3 appeals, there are 8 various motions and petitions being submitted to the court this morning. All of the submissions and the court's decisions handed down today are available on the court's website.
Okay, thank you. Our case for oral argument today is Jane Doe and Mark Myers versus Amy Fecher in her capacity as Secretary of Transformation and Shared Services and the Arkansas Democrat-Gazette, CV-20-560. Justice Wynn is not present, but will view the court's live stream of the argument and will participate in deciding the case. Justice Womack has recused from the case. Special Justice Emily White will be serving in his place. We welcome Justice White to the case.
Thank you, Chief.
And at this time, the court will recognize counsel for appellant, Mr. Sprinkle.
Thank you, Your Honor. I apologize. My microphone is this phone that's in my lapel pocket, so I'm not playing with my phone. That is my mic. I represent Mark Myers in this case, and I will present on behalf of him first. May I begin?
Yes, you may.
So this case involves the interpretation of the Freedom of Information Act and the provision that of determining how to determine whether a record is a public record or whether it's not a public record. And this court has previously said in 2 cases dealing with 2 of the Pulaski County cases that are cited in the briefs, that just because a record is held by the government, it does not mean that there is a that it is a public record. The appellee has asked that those cases be overturned, and it asserts that the analysis of determining in camera whether a record is a public record is an analysis that will violate the clear language of the statute. The statute says that a record that is held by the government would be presumed to be a public record. It is our position that those do not conflict, that presumption is rebuttable. And what the court has laid out in the 2 Pulaski County cases is the way that you look at the content of those messages to determine if that presumption is rebutted. And so we're talking about a procedural position of how do you look at the records to determine. Without a way to analyze the records in camera, there will be no due process for the party who is trying to show that the records are not public records. And in this case, there are over.
Counsel, the trial court did an in-camera review, correct?
It did.
And so, and it made a finding of fact that there was a substantial nexus. So what are you asking? Are you asking this court to overturn that finding of fact?
So I am asking both. One, I do not believe that the record is clear that the court made a finding of fact based on the messages, and that's because the court statements soon after it reviewed the messages was unequivocal that some of the messages are purely private, that lots of the messages were purely private, and the court instructed us to undertake to see which ones we agree are purely private and then parse those out from the ones that aren't. The court intimated that some were not private and some were private. When it changed that course in July, it did not indicate that it believed that those records that it previously stated were certainly not releasable. It did not say that it changed its opinion on whether they were private or not. It said that it changed the way it analyzed the case. It switched from a message by message analysis and grouped everything together and said that because of the context of the relationship, that is why everything is releasable in its whole. And the court did not make any specific finding that or it indicate that it changed its opinion about whether or not those specific thousands of messages were mostly private. It simply said that it is not analyzing it like that. The specific words, it specifically said that Jane Doe's position is why the whole thing is relevant. And so essentially the court said that because of the relative positions of the parties, that everything should be released, and then the public should parse out whether or not there's a nexus to work or whether or not it affects the performance of a function. And that approach is expressly what the Pulaski County first case said that is not what should happen. I think that is notable that in this case, none of the messages were a violation. None of the messages showed that Mr. Myers failed to perform a duty. None of the messages showed that he did anything wrong. The messages that could possibly be released are only those messages could only be released for the public to determine what they think, for the public to determine whether or not they believe that those specific statements could have been could have affected his job performance. The records that do not indicate any job performance at all don't even allow the public to do that. Those records are solely private, and so those records don't even help the public in what releasing the statements would, what releasing the records would do. The distinction between the first Pulaski County case, in that case, the person, the appellant did.
And counsel, to be clear, I guess I'm asking, what exactly are you asking us to do? If the judge said I can't separate them, they're inexplicably entwined in a sense. Are you asking us to send him back to ask him to do something he said he couldn't do?
Yes, Your Honor, and it's because I don't believe that he said he couldn't do it. I believe that he changed the way he approached it and decided not to do it. And so earlier he clearly indicated that it could be done, and that's what he tasked us to do before COVID hit, was to do it. And it can be done because the vast majority of the records were clearly private in nature. There was only a small portion that even the appellee asserted at that time had any nexus. There were only about 200 messages that even they brought up with the court that they believe should be released, and some of those required context. And so of those 2,700 or so, about 2,500 or more, there was no question about they were easily separated. And so what the court did later was it changed its approach to a context-driven approach rather than a content-driven approach. However, even if we also do ask that if the court finds that the trial court did actually look at the records, which I believe it indicated that it did not take a content-driven approach, that looking at the content of those messages, that looking at the content of those messages the court's decision would be clearly erroneous. The content of those messages, again, even by the court's own statements earlier on, are clearly, the court was very unequivocal immediately after it read the messages that some of these should not be released. And it never changed that position. It only said that now it's looking at it as a whole. It's looking at it in context, and in context, it does not feel that it needs to separate them out. But the court never changed its factual finding earlier that some of the messages were certainly personal in nature. And therefore, we ask that this court remand the case so that this court remand the case so that the court can undertake the proper analysis, and also that to the extent that the court interprets the lower court's decision to have apply the content-driven analysis, that analysis based on viewing the records, based on the court's own statements, and even based on the statements of the appellee earlier on in the case, that there are certainly some records, and it's our position that is the vast majority of records that were purely personal in nature and should not be released. And I'll pass the rest of my time to counsel for Jane Doe.
Thank you. May I proceed?
Yes, you may.
Thank you. May it please the court, counsel. I represent Jane Doe in this appeal. I'd like to speak just a little bit about some things that Mr. Sprinkle mentioned. I want to be clear to this court that the circuit court never said in any way, shape, or form that it was impossible to segregate the messages. And I asked this court to review the messages yourself. You need not review 2,500 messages. You can review a small portion and see very easily that there are messages that can be segregated, redacted, struck, very simply without affecting the integrity of the surrounding conversation. We, in the lower court, we did that.
So counsel, what did the court mean by inextricably intertwined if the court did not find they could not be separated?
Your Honor, my understanding of the court's order is that the court, I think, conflated some of the holdings in the Pulaski County cases, and instead of the inextricable intertwinement, meaning he couldn't segregate them, he used that as the nexus, which I don't think is permissible. I think he should have explained what was the nexus. I don't think that simply saying they're intertwined supplies the nexus. One can see very clearly by looking at them that you can redact. I mean, there's some very sexually explicit exchanges, some very personal exchanges that, you know, as simple as, well, I don't really want to repeat some of the sexually explicit material, but you can see very simply.
We've seen them, so.
And so I don't think that that should suffice to establish a nexus where one does not otherwise exist as to the messages when they're independently considered. The circuit
Counsel,
Yes.
one of the things that's different from Pulaski County to here, that it's a little bit easier to pull out and, you know, email by email and see that an email's personal and remove it, and an email is business related and remove it. But when you're looking at chains of text messages, sometimes a text doesn't make sense, you know, unless you're following the previous text. And looking at it, for instance, you know, I looked at just the month of October, and if I did a day by day, I could only find like 2 days that didn't have a business reference in every day of text messaging. So if we stick with the substantial nexus test in Pulaski County, then it's every day except 2 had a business reference in that day. So, I mean, do we say pull out the days that don't have a business reference? Or, I mean, we're asking a judge to go through 2,700 and try to parse when the prior text didn't include something that you have to include to make the next text make sense? You know, I guess and how do we set that as a standard?
Thank you, Justice Wood. It is our position that you should strike the messages that have no relation to business and are not required for the context to be understood with regard to the business messages. So if you'll look at some of the spreadsheets that we supplied identifying definitely business messages, more importantly, the one that identified highly private messages, you can remove those without changing any of the context of the remaining messages. And it's really a very small portion of the overall communications. It's important to note too that these aren't text messages in the traditional sense. And so while we have a spreadsheet, that's obviously not the way that they were exchanged. So you kind of have to imagine when there's a passage of time in there, the two that appear to be in a row may not actually be connected because of the time passage between those messages. Also, I think it's important to note that in the Pulaski County cases, the parties agreed that sexually explicit material was not at issue. It wasn't at issue at all. The parties did not litigate that. And in this case, that is exactly what we are litigating. We also don't have
counsel. And my other question is, you're on the opposing side, they suggested that Pulaski County was not good precedent. And so I'm wondering if perhaps you agree with that, and maybe you're suggesting that the substantial nexus is not a good test. And it sounds like you're saying that we should go with the solely personal part of Pulaski County. And if a text is solely personal, then that should not be turned over under FOIA. Is that the standard that perhaps you're suggesting?
I think both can work together, and I think that's what Pulaski County intended. We parse out communications that have a substantial nexus to business. If there is not a nexus and it is solely personal, it is not made public. And I think Pulaski County makes it very plain that you have to review the individual communications in order to make those determinations. You know, it's also important to note that we don't have the emails that were at issue in Pulaski County. So we all are kind of trying to figure out what the words on paper in the opinion mean, but we can't, see the demonstration. I read Pulaski County to mean that in individual emails, those two parties were talking about business and about personal matters such that it was impossible to make any kind of redaction that wouldn't deplete the credibility or the context of the remaining communication. And that's just not the case here. Here, just like other areas of the FOIA statute, we can easily redact without compromising the integrity of the document or of the record itself. That is contemplated by the FOIA statute and many other circumstances, which I think I outlined in our brief. That's not an unusual occurrence. And in fact, we do it to protect public figures quite often. The statute contemplates that. So I would submit that these Pulaski County cases should not be overturned. There is no reason why this is not good law. There is not an internal inconsistency in any way. It can easily be applied if we all just do what the case said. And in this instance, the circuit court really skipped the meat of its role. We all went to court and the court expressed that it was going to follow that process that was outlined in Pulaski County. And that's what we all anticipated. And then there was an about face and that was the end. And I would submit to you that this court should remand this case and ask the circuit court to comply with the holdings in Pulaski County and let us go through the individual messages and parse out those that have no relation whatsoever to public business and are purely private communications between two consenting adults. And I believe my time has expired and I would reserve the rest for rebuttal.
Okay, thank you. The court will recognize the appellees. Mr. Gaines.
Good morning, Your Honors. Alec Gaines. I'm with Steelwright Gray PLLC, and I represent the Arkansas Democrat-Gazette. This case involves a significant public interest, sexually explicit relationship between a government official and a government contractor. I first want to begin with the continued viability of Pulaski 1 and Pulaski 2. The lower court in this matter, of course, utilized this court's analysis in Pulaski 1 and Pulaski 2 to determine whether the records were public records. Now, Justice Wood brought up a good point a few minutes ago when she asked, what is the proper standard review of that? And I think it is clearly erroneous, because the court made factual determinations about what those messages meant and whether they had a substantial nexus with business affairs. But as to the continued viability of Pulaski 1 and Pulaski 2.
Counselor, wouldn't you agree that some of these messages are clearly private in nature and they don't meet the definition of a public record under FOIA? I mean, it doesn't take a rocket scientist to go through and see that messages that include body parts and such are personal in nature.
Respectfully, Justice Hudson, I do disagree with that. I think if you look at the context in which these messages were sent, I don't think you can dive into the minds of the parties at the time they sent them. So,
so really, you want all of them?
Well, I mean,
you don't back up on any of it.
But, I think there is no sexually explicit exemption within FOIA for these types of records.
There are privacy concerns.
There's a constitutional privacy concern, and Doe raised that issue. But I think the court looked at that and said, we think the public interest outweighs her privacy interest in those types of messages.
Well, explain me about face, please, of the trial court that Ms. Castanelli was referring to.
Well, the trial court looked at the issue.
At one point, and asked you all to go sit down and figure this out. And then in the midst of COVID, does an about face and says, nope, you can have all of them.
No, you're exactly right, Justice Hudson. He looked at all the messages. He went above and beyond what they did in Pulaski 1 and 2. He developed a spreadsheet and tried to, and this is what Justice Wood was talking about a few minutes ago, it's really hard to try and determine what's purely personal versus what actually has a nexus with business. And, he tried to do that, and eventually he determined he couldn't do it. And that's when the second order came out. He notified us that he wanted all the records released because they were inextricably intertwined. And that's a tough phrase to say, but that, he said that several times. And
Mr. Gaines, you mentioned a spreadsheet, but there's no spreadsheet in the record that the judge prepared in circuit court, is there?
Justice Kemp, I'm not sure if that's correct or not. I've seen 2 spreadsheets in the record. I know that one submitted by Doe, and I believe the spreadsheet was originally submitted by DIS, but yeah, I'm not positive whether or not that is in the record.
But there's no chart that the judge prepared that he's relying on that we can look at and see, yes, this is what he relied on to make this decision. We don't have that before us, do we?
Your Honor, I'd have to look. I'm not aware of it offhand.
What spreadsheet are you referring to?
I think it might have been in materials that Doe submitted. I can look. I believe Doe submitted that as part of her motion for clarification.
And now you want to use that against her?
I don't understand your question, Justice Hudson.
Well, I mean, you are referring to it as if the trial court made this spreadsheet.
The trial court had his assistant identify records that could possibly be business related and try to connect those with I guess the context of why they were sent, and he determined he couldn't do it eventually.
Well, and I'm just following up on the Chief Justice's question about where's the spreadsheet that you're contending the trial court made, and is that in the record?
If it's in the record, it would be attached to Doe's motion for clarification. I think it was in there, but I'm not sure offhand.
Counsel, when you talked about, so even if we said that these were records under FOIA and subject to disclosure, and you said that the judge weighed the personal interest versus the government interest, how does a circuit judge do that without taking any testimony and having a hearing? Because that did not occur here.
You're correct, Justice Wood. I think he made that determination based on the contents of the messages. And he looked at the context of why these messages were sent. We're dealing with multi-million-dollar contracts with a government contractor. And he determined that the public interest in seeing why these contracts are made and the relationship between these two, he determined that outweighed the privacy interests of Doe. And to be clear, Myers has no privacy interest. He waived it. He sent these messages on a government phone. So anything that he sent, all those sexually explicit messages, he has no privacy interest in those.
And again, how do we really know he waived it? And then how do we know Doe waived it if there hasn't been a hearing? I particularly was interested, and again, we compare with Pulaski County to make sure the court's being consistent, but how exactly the government got access to this? And how do we know that this became a public record when we know this was sort of privately encrypted? This wasn't like Pulaski County. It wasn't on a government email. How do we know this became a public record maintained by his agency when, again, we don't have testimony, and we don't have testimony about any waiver by her that would protect her identity?
That's a good question, Justice Wood. And I'll tackle that in two different ways. So
sorry, that was like 5 questions in one.
For Mr. Myers, it's clear. He says in his complaint that he knew that DIS backed up his BlackBerry messages. He sent these from a BlackBerry message. He probably sent them from his computer as well. And he knew, he had knowledge that DIS backed these up for 90 days. He cites that in his complaint. Not only that, he referenced it in his letter to the AG's office when he was seeking review of the release of the records. And I can give you a record number on that. I don't have it handy, but he specifically references that he knew that DIS backed up his BlackBerry. And,
Well, even still, Counselor, what about Jane Doe? I mean, even if all of that is true about him, what about Jane Doe? And what Justice Wood is getting to is the trial court didn't have opportunity to hear any testimony from her about whether or not she believed that possibly these messages were being sent from a private device. And I mean, we don't have that. We didn't have an opportunity. The trial court didn't hold one hearing.
You're correct, Justice Hudson.
I don't know that the analysis is like the basis of Mr. Myers, but rather Jane Doe and her privacy interests. So I speak to that, please.
Absolutely. So I think the court based its analysis on the messages themselves. And as to a waiver, we made that argument. We identified messages that we believe showed that she knew she was communicating with Myers on a government device. I think common sense would say, well, he has a BlackBerry, a government issued BlackBerry. We're doing BlackBerry messages. I think from a common sense standpoint, I think you can make that correlation. But the court didn't rule on waiver. The court didn't rule on that. He went straight to weighing the privacy interest versus the public interest. And he felt that the public interest in these records, given the relationship, given the government contractor having a sexual relationship with the head of a department, an agency, where there's millions of dollars going back and forth between those parties, he ruled that the public interest in these records outweighed the privacy interest. So I don't necessarily think he ever even got to waiver.
Well, and is there a public interest in her medical information and any, what's the public interest in that?
That's a good question, Justice Wood. If you read the record closely, the AGG did not request medical records. We repeatedly said that we didn't want them. So I'd hate to speculate about why Judge Piazza determined that the public interest outweighed the privacy interest in those records. If I had to speculate, I would say perhaps it provides a window into Doe's mind frame at the time and why she made some of the decisions she did. I don't know that, but if I had to speculate, that's what I would speculate.
And what would be the government interest that outweighed her private in her phone number?
To be honest, I'm not, we wouldn't request that either as the ADG. I'm not sure that would be disclosable.
And I think you're probably seeing what I'm getting at is that we don't have a lot of analysis from the particular judge that he made these sort of detailed decisions.
I don't disagree. I think he could have expounded on some of these issues. But again, if you read that order, he very clearly felt that the public interest in all these issues outweighed the privacy interest. And that's really the only answer I have for you.
Or possibly it was too tedious. I mean, it was going to require a whole lot of effort to go through them. And instead, throwing the baby out with the bathwater seems to be the about face that occurred here rather than a thoughtful analysis that is reflected in the record.
Justice Hudson, that may be the case, but I do note that he did ask the parties to redact family names, and we never asked for family names. We said that should be redacted. And you know, Aaron mentioned this before, but we did early on request that certain sexually explicit messages not be released. And that was under a plain reading of Pulaski 2. Now, of course, now we take the position that Pulaski 1 and 2 should be overturned, and which will bring that back into play. But, you know, again, the court determined in its view that the public interest outweighed the privacy interest, even in those messages. And again, I note that most of those sexually explicit messages are from Myers, who has no constitutional privacy interest, because he knew he was sending these messages from his government-issued phone. I do want to return to what the viability of Pulaski 1 and Pulaski 2.
Well, and I just wanted to be clear that your position is that any state employee that sends any message from a government device, that any personal message is discoverable, is the position you're taking.
Is it discoverable or disclosable?
Disclosable, I guess.
That is not my position. My position is you still have to do the test. If you follow Pulaski 1, you have to determine whether or not it was purely personal or whether it had any sort of relation to the government business.
So the general employee that is not having a relationship that is impacting a government contract would not have to be concerned that their information would be disclosed.
No, Justice Wood, because I don't think it would be a record of the performance or lack of performance of a government worker. And that's what the plain statute says. And that's why I appreciate the dissents in Pulaski 1 and the concurrence in Pulaski 2. If you look at the plain language of the statute, it's a record of the performance or lack of performance of the official functions. And I think where Pulaski 1 goes awry is that it adds the substantial nexus test, which was never utilized before. It's from a Colorado Supreme Court case. And it just moves us too far away from the statutory language.
Well, it's not lack of performance if a secretary sends 10 personal emails when she gets to work in the morning.
I like the concurrence in Pulaski 2's analysis of that situation, Justice Wood. What I think it was Justice Danielson said, it's really a case-by-case basis. And by no means is he saying that by going back to statutory language, every personal email or text sent by a government employee is subject to FOIA. It still requires an analysis of whether that is a record of the performance or lack of performance of that government official.
Well, and I guess going to thinking back to the original intent of FOIA, do you think that what they meant were records of lack of performance that were kept more in a personnel nature, not anything that you could stretch to make it be a lack of performance?
Likely, yes. I mean, here you have messages that were sent that were part of the criminal investigation into Mr. Myers. And those were the ones that are turned over to us. So I think if you're looking at it on a case-by-case basis, this is a good example of, you know, if you look at them individually, some of them do appear purely personal. But if you're looking at it in the context of why they were sent, and like you said earlier, if you can't just parse these out one by one, they all connect to each other. That's how text messages work. You can't analyze it like you would an email. So when you do that, clearly the personal, in my opinion, and the court's opinion, you know, reflect on the performance or lack of performance of official duties. If there are no further questions, I'll concede the rest of my time.
Okay, thank you. And the court will recognize a rebuttal for the appellants.
Thank you, Your Honor. I want to start with the discussion about the content of the messages and be very, very clear. What body part, as Your Honor put it, was being discussed, Doe's medical issues, her personal family issues have absolutely no value to the public. They tell the public nothing. The public interest is in the fact of the relationship and the circumstances as they existed at the time relative to DIS. It is Mark Myers' performance that is at issue, not Jane Doe's. Opposing counsel mentioned something about, well, they showed Doe's frame of mind and her reasoning for making decisions. That is not a public interest. She is a private citizen, not a public official. And so I submit to you, again, very easily redact the ones that have no connection to Mark Myers' business for the state. The ADG never agreed to redact any of those messages. So please don't believe that we just wouldn't agree to that. I think it's clear from the record that after the first hearing, or maybe it was the second hearing where the court sent us to confer, we were very ready to negotiate and determine what was and wasn't public and be done with it until we got blindsided. As to the spreadsheet, Justice Kemp, you mentioned, I don't actually believe that the court spreadsheet is in the record. The court never made it an exhibit. It was informally emailed to us, but it is discussed in the record in the hearings. And the discussion is that the court's clerk was able easily to parse out what was business. I mean, it's just that simple. It's not impossible. They did it. The circuit court gave no explanation of Doe's privacy interest, how substantial it might be, what the weighing process looked like, what the tipping point was. And I think we have to have that information. We at least deserve an opportunity to discuss it, to argue it. There was discussion about he did this on a government phone. And the lack of discovery here is problematic. It's difficult for this court to review these matters without having had a record. But you do have some evidence, and that evidence is in the form of Jane Doe's affidavits that went unrefuted entirely. And those affidavits established that this was not limited to a phone. This was a cloud-based, internet-based application. And by the way, you know, now we have a lot of these. Back then, there weren't that many of these. And so you really had to go the extra mile to encrypt your messages and make sure that they aren't device-specific. And these parties actually used email and text message and traditional forms of communication to communicate about business matters. Had they not believed that the BlackBerry application would be private, there would have been no reason not to just text. I want to go back quickly to the substantial nexus. This came up early in the argument, but I believe that that is a mixed finding of fact and law that really needs to be parsed out better by the circuit court in order for this court to adequately review it. He's conflated two propositions there, and it's just very difficult to even really understand and explain the circuit court's logic and his words in his order. I want to touch briefly on her name. I believe Justice Wood mentioned her phone number. I cannot imagine how that could have any public value. We don't even allow public officials' phone numbers to be disclosed. So it makes absolutely no sense that we would disclose this private individual's phone number. And her name also has absolutely no public value. She could be named Cindy, Susan, whatever, and it would make no difference. The important issue there is what Mark Myers did in his position at DIS and as it relates to a vendor. her status as a vendor. It is not her name. And to include her name is frankly just outrageous to me. Opening her up to the harassment and the public ridicule for absolutely no additional public value, to me, flies in the face of the Constitution and of even the FOIA exemptions as they exist. Also, the legislature, as we all know, is perfectly aware of those Pulaski County cases.
Excuse me, Counsel, your time has expired. Let me ask, are there any questions of members of the court? Okay, if not, that'll conclude our oral argument today. Thank you, all counsel, for your presentations today. And court will take a 15-minute recess before we reassemble for our case conference. And this session of court will be adjourned. Thank you.